I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into compilation number 271. And for this compilation, we will be in 3 different judges' courtrooms. Before I give you the names of those judges, don't forget to like, comment, share, and subscribe. It is much appreciated. Also, if there were commentary in these proceedings, it will still be there, and chapters will be added for your convenience. Now, the 3 courtrooms we will be in on today. First, we will be in a courtroom from out of the state of Colorado. And as I've been saying recently, it seems like Colorado is trying to take the place of Michigan when it comes to the most sovereign citizens. Unfortunately for this particular judge, we do not know his name, so this will be an unknown judge. If any of you guys know who this judge is, please put it down in the comments. Also, for our second proceeding, we will be in the courtroom of Judge Bryant out of the state of Michigan. And for our last proceeding, we will be in the courtroom of Judge Jennifer Grant out of the state of Washington. As always, it is a pleasure to bring you guys these compilations. I look forward to bringing you many more. And now let's jump into 271.
Jared Sullivan, 25 M426 24 M439. And good morning. Can you tell me your name, please?
Jared Mark of the family Sullivan.
People, what is the outcome of your conversation, Mr. Sullivan?
Your Honor, Mr. Sullivan indicated to me that these are likely going to become trial cases. I do have a note in the file that Mr. Sullivan filed a discovery demand, but has not yet come to our office or requested that discovery in any way. So I did inform him that he can go upstairs to our office and request that discovery. I also offered to provide the Larimer County website where you can make a discovery request, but he did not want that website written down for him. So I've instructed him up to the 2nd floor to request that discovery after this court date.
Okay. Mr. Sullivan, what are you asking the court to do today?
Well, I'd push for another dismissal based on failure to state a claim.
Mr. Your motion to dismiss is settled, and I will no longer be considering any more motions based on the grounds you previously asserted.
Well, and your response to that is just adding claims onto the record that haven't been brought up by either parties. And it leaves the appearance that you're acting outside of the bounds of your duties as an independent third party.
You are asking me to review motions and issues that I reviewed, I think, last year and already acted on, and I'm not doing that again.
Do you have an oath to the Constitution on record, sir?
Beg your pardon?
Do you have an oath to the Constitution on record?
We've discussed this, and so we're going to move on. You are choosing to...
Do you have an oath of office on record to the Constitution, sir?
Sir, you may not interrupt me. I'm going to go through... You are choosing to represent yourself, is that correct?
Yep.
Then I have to ask you some questions. And I think I've asked you this before, but we'll go over it again. Are you currently under the influence of any drugs, medication, or alcohol that would affect your understanding of these proceedings?
No.
Do you understand that you have the right to be represented by an attorney throughout these proceedings?
Yes.
Do you understand that if you cannot afford an attorney, that an attorney can be provided to you at no charge to you if you qualify financially for that service?
Yeah, we've already done that.
I know, but do you understand that?
Yeah.
And do you understand that I would appoint counsel to represent you if you wanted an attorney to represent you, provided you meet that financial eligibility requirement? Do you understand that?
Yes.
Do you have any legal training?
No.
How far have you got in school?
Some college?
Do you understand that the criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and presenting and representing your defense?
No, I don't understand that because I haven't seen evidence of it.
Because what?
I haven't seen evidence of that, especially through the attorney that I was provided that offered ineffective assistance of counsel.
Well, all I'm asking is, do you understand that the criminal, I'm not asking you to, about the specifics of the case. Generally, do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and presenting your defense?
In theory, yes.
Do you understand that you will be held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications of an attorney?
No.
You don't understand that? I will explain it. You will be held to the same rules and laws as an attorney, even though you don't have the same training and qualifications. For example, the district attorney just discussed discovery. An attorney who is trained and qualified knows that they have to make a request to the district attorney to disclose the discovery. The district attorney doesn't just automatically provide it. Once they get that request, they will provide what they're required to provide under Rule 16 of the Colorado Rules of Criminal Procedure. The district attorney has said that you have not made that request yet. So that would be an example. So if you came back at trial and told me they never gave you discovery, then I would hold you to the same rules and laws as an attorney would be held to, which is that if you didn't request it, then that's on you, not them. So that's an example of you being held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications as an attorney. So do you understand that?
I don't, because my attorney, the ineffective assistance of counsel that was provided by the court, had already requested that discovery, and I keep filing the same discovery requests because they refuse to release it. Exculpatory evidence.
So I'm not, again, asking you, I just used an example from your case to illustrate the general idea. The general idea is, do you understand you will be held to the same rules and laws as an attorney would, even though you do not have the same training and qualifications as an attorney?
Sure.
All right, court will find that decision is knowingly and voluntarily made. So in 25M426, what is your plea to obstructing a peace officer, guilty or, well, actually, I should probably have the people recite the last offer communicated to Mr. Sullivan on one or both of these cases if it's a global offer.
Yes, Your Honor. In 24M439, the last offer was to plead to original count 1, no proof of insurance with a $500 fine and 4 points against the DMV. In 25M426, the last offer was to plead guilty to original count 1, obstructing with 6 months of unsupervised probation and ISAE discovering better choices class within 5 months, 16 hours of UPS within 5 months, and to remain law-abiding. Both of those offers are now revoked.
Well, we'll get there in a minute. So in 24M439, if the plea of guilty is to count 1, does that, am I correct in inferring the offer contemplates dismissal of the remaining counts?
Yes, Your Honor, I apologize.
Mr. Sullivan, did you hear what the district attorney just communicated?
Yes.
If you enter a plea of not guilty, all of the, you will be communicating to the district attorney, you would not accept that offer. You'd be communicating, and the district attorney is free to withdraw it. And if they choose to withdraw it, they may choose not to put any new proposals on the table for a resolution of either case, which may leave the trial that I set as a result of your not guilty plea as being the only way to resolve the cases. Do you have any questions about that?
No.
So in 25M426, what is your plea, guilty or not guilty?
I do not consent to enter any plea on my behalf. I do not comprehend or understand how to enter a plea, as there is no injured party in this matter and no evidence of any contractual obligation requiring performance to follow the corporate state of Colorado statutes, codes, ordinances, and rules that are merely policies of the corporation acting as government under the color of law outside the bounds of the constitutions of the United States and the state of Colorado.
All right, so it sounds like you're refusing to enter a plea, is that correct?
Yes, sir.
And the court will enter a not guilty plea on your behalf. On 24M439 to count 1, driving without insurance, Count 2, obstructing a peace officer. Count 3, driver's license refusal to display it. Count 4, fictitious plate. What are your pleas, guilty or not guilty?
I do not consent to enter any plea on my behalf. I do not comprehend or understand how to enter a plea, as there is no injured party in this matter and no evidence of any contractual obligation requiring performance to follow the corporate state of Colorado statutes, codes, ordinances, and rules that are merely policies of the corporation acting as government under the color of law, outside the bounds of the Constitution of the United States and Colorado State.
So am I also correct in inferring you are refusing to enter a plea in 24M439 as well?
Yes, sir.
Court will enter a not guilty plea on Mr. Sullivan's behalf. Are you requesting a trial to the court or a trial to a jury on these two cases?
I'm demanding a trial by jury.
All right.
And are you planning on scheduling those back-to-back, Judge? Was that my understanding?
I beg your pardon?
Are these trials scheduled back-to-back?
Right. So if one will go and the other one will get continued.
Okay.
And Mr. Sullivan, are you ready to proceed to trial?
No, I don't believe so. Well, maybe on the 439 case.
I
know
need a
that.
yes or no answer to know how to proceed next.
Well, I was prepared. I didn't know we were splitting them back up.
Beg pardon?
I didn't know that we were splitting them back up.
Why we're splitting them back up?
Well, they're scheduled for the same day for this trial next week.
Right. They wouldn't both go to trial at the same time. One or the other would go.
Okay. Well, then, yeah, I can do 439.
All right.
And that 426, I'm still waiting for discovery and disclosure of witness names.
Then I will note that the deadline for resolution is February 23rd at 12:30 PM. Will you be requesting the new reasonable doubt instruction?
Yes, sir.
The new reasonable doubt instruction reads as follows. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If you are firmly convinced of the defendant's guilt, then the prosecution has proven the crime charged beyond a reasonable doubt. But if you think there is a real possibility that the defendant is not guilty, then the prosecution has failed to prove the crime charged beyond a reasonable doubt. And a reasonable doubt can be based on the evidence presented or the lack of evidence presented. New reasonable doubt. Are you going to have an objection to me reading that reasonable doubt instruction to the jury?
Pardon me?
Yes.
I'm fine with that. That's fair enough.
People, how long are you asking for voir dire?
It's 10 minutes, Your Honor.
Mr. Sullivan, how long are you asking for voir dire?
For what?
Voir dire.
I don't know what that is. What's done?
It's the process where you ask the jury questions to find out ahead of the jury being selected, whether or not the people who are called to serve as jurors can be fair and impartial.
Is that between individuals or in lump?
Mr. Sullivan, you may recall when I gave you an advisement that said that if you're choosing to represent yourself, you need to understand that you will be held to the same rules and laws as an attorney would, even though you don't have the same training and experience as an attorney. So I'm not planning, I'm really not able to coach you through this process. I'm expecting you to come to court already having this knowledge of what will be happening at a jury trial.
Well, all I can do is guess at this point.
Let me put it this way. We will not slow the trial moving forward because you are not knowing or understanding things you should know or understand ahead of time. For example, voir dire will be 15 minutes in length, regardless of how long, once you have figured out what voir dire is, how long you want to use on voir dire. It'll be 15 minutes in length. How long are the people requesting for opening statements?
5 minutes, Your Honor.
Mr. Sullivan, is 5 minutes going to be long enough for you to make your opening statement?
Maybe go 10.
The court will allow 5 minutes for opening statement because what needs to be, what is stated during opening statement is a recitation of facts. It's not argument or commentary on the law. And 5 minutes should be adequate to cover that. People, how long are you asking for closing?
10 minutes, Your Honor.
And sir, how long do you think you need to close?
I imagine that'll work.
Beg your pardon?
I imagine, well, clearly you're just gonna say 10 minutes, so I'm gonna say 20 minutes. Because I'd rather have extra time, whether I need it or not,
Well, I will allow
than
15
getting cut
minutes.
short.
I will allow 15 minutes for closing because there are 4 counts. Those counts do not all rely on the same evidence. So there may need to be a little bit more argument regarding how the facts fit or don't fit with those elements. Will any witnesses need special accommodations, people?
No.
Are you planning on using the courtroom technology?
Yes, Your Honor.
Mr. Sullivan, were you planning on using your computer to publish exhibits to the jury?
To my knowledge, that's the only way to do it, is if I bring my own
I
equipment.
don't understand what you're saying.
To my knowledge, that's the only way to do it, is if I bring my own equipment, right?
Well, no, you can have paper copies and share them with the jury by having them look at paper. The reason why I'm asking if you're planning on publishing with a computer, then you will be using the courtroom technology to accomplish that. And again, it's a situation where you need to be ready to have that going, because I'm not going to wait to troubleshoot issues. We won't be troubleshooting issues in front of the jury.
Okay.
I don't know if I can ask about exhibits, conferring on exhibits, because I don't have an exhibit list.
I haven't been provided any either.
All right, Your Honor. As I said, I will immediately after leaving here, I will provide that and also get some good contact information from Mr. Sullivan so he and I can confer so that we can make sure that there are no issues going into the trial.
All right. Do you have exhibits that you intend to admit?
Just body worn camera, Your Honor.
I'm sorry, I'm
Oh.
speaking to Mr. Sullivan.
Oh, yeah, I've got an exhibit list turned in.
Right, but the question is more directed. Well, you answered my question, so I'm going to ask the next question, which is, do you know how to admit exhibits?
Probably not. As far as getting them to the clerk or?
No, getting them in front of a jury.
Oh, no.
Asking me whether or not I will allow the exhibits you have to be in front of a jury, to see, to allow the jury to see and consider the exhibits as evidence.
No, I don't.
Okay. Again, that's something you are expected to have ready. You are expected to have, you are expected to be ready to do. And so what I'm not going to do is coach you through the process. And what I'm not going to do is wait for you to figure out how to admit it in real time. I'm telling you this now so that you are not surprised when we get to the trial. I don't know if there's anything else I need to take up. This trial is second in priority, so if Mr. Bangs is ready to proceed to trial, this trial will be continued. If Mr. Bangs is not ready for trial for any reason, then this trial will proceed. With regard to 25M426, I granted the people's request to add count 2 speeding 20 to 24 miles over posted speed limit. Class A traffic infraction, count 3, failure to provide proof of insurance, a class 1 traffic misdemeanor. And count 4, displaying fictitious or altered license plates, a class 2 traffic misdemeanor. All also alleged to have occurred on April 7th, 2025. What is your plea to those 3 newish counts, guilty or not guilty?
I don't consent to enter a plea. I was never served with any of the documentation for that motion.
So the court would first note that it's your responsibility, sir, to make sure that we have current contact information. So the information that when we take an action on this case, you're notified about it.
Are you insinuating that my contact information has changed?
I granted this motion on November 12th. Did you receive a copy of my order?
Yeah, I did, and I objected to it, and
Then and did you get a copy of the motion before ahead of my order granting it?
no, I just got the order granting it. I didn't receive anything.
So do the people have current contact information for you?
It hasn't changed.
What?
It hasn't, my contact information hasn't changed. My mail continues to go to the same address. That is the only thing that I have noticed.
So people, it appears you have the correct email address, and I don't know if you've been emailing copies of what you've been filing, but you are not sending information to the correct mail address. You have it as Fort Collins. It's not Fort Collins, it's Loveland.
Understood, Your Honor. I'll make sure that we update that in our system. I do believe, though, that through e-filing, he should be getting automatic mail notifications.
What now?
Should he not be getting mail notifications through e-filing? No? Okay. I'll just double check to make sure that we have the correct address on file so we can ensure that that is getting sent to him. Also make sure that I just email him copies of everything that's been filed in the case thus far. And as I stated earlier, I'll get in touch. I'll speak with Mr. Sullivan right now to get some updated contact information so we can confer about everything regarding both of these cases.
Court enters a not guilty plea on Mr. Sullivan's behalf, and on counts 2 through 4 in 25M426. 25M426, the request to continue is granted. Anything else we would need to take up for Mr. Sullivan?
Just to ensure that we focus on the actual law as it stands and not some of the superfluous materials which have come up throughout the case.
I intend to keep a tight lid on this case may be about and what it may not be about, which, Mr. Sullivan, I think the best information you should take away from that answer is if I make a decision about an argument or a piece of evidence that you disagree with, you are free to object. You are not free to argue with me about it. If I sustain an objection to a piece of evidence or an argument that you make, you may not try again to get the same piece of evidence or argument in front of the jury. I shouldn't have to sustain an objection more than once to a particular piece of evidence or a particular argument. I'm expecting full cooperation with that, and if you believe I'm mistaken, you are free to object, and if I overrule your objection, your remedy is not to either keep arguing with me about it or to keep making the same objection over and over again. It is to wait to see the outcome of the trial, and if the outcome of the trial is a conviction, then you may appeal any error that you think I might have made. Do you have any questions about that?
No, I've made it clear that I don't feel like there is a fair trial involved. So I'm just here for the rigmarole so we can get to that.
There's a lot of distracted defendants this morning. And if we're not going to be able to come to court appropriately on Zoom, we're going to have to come in person. So I'm going to attempt this. I'm going to attempt to do Mr. Harris's case. But Mr. Harris has 2 and 3 devices. He keeps putting his fingers and stuff up to the camera. I'm not going to be able to do it. So if Mr. Harris is not going to be able to be stationary seated in an upright position and not keep putting his fingers and stuff in the camera, he's going to have to come in person. This is case number 234579701, the people of the state of Michigan versus Michael Eric Harris. The defendant is charged with 1 count of driving while license suspended, revoked, denied, 1 count of security fail, and 1 count of unregistered motor vehicle. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And yes, Your Honor, Brandon Bird on behalf of Michael Harris. Mr. Harris, can you please unmute yourself and state your full name for the record?
Greetings. This is Harris Michael Eric, authorized representative of Michael Eric Harris.
I only want Michael Eric Harris. I don't want any authorized representative. The law indicates that there is no authorized representative on behalf of the person. If Michael Harris is not present, then the person who's holding up those papers should not have come to court. So I'm going to go ahead and remove them, or I put them back in the breakout room. You can find out if this is Michael Harris. If it is not Michael Eric Harris, I don't want to speak to him. I am not going to conduct court with anyone other than Michael Eric Harris. So this person can go back to the breakout room and you can find out if this is Michael Harris. If it's not, then they're free to go. This person who is free to go, who is holding up papers saying he's not Michael Harris, is free to go if he's not Michael Harris. All right. Okay, I'm ready to recall case number 234579701, the people versus Michael Eric Harris. The defendant is charged with driving while license suspended, revoked, denied, operating an unregistered motor vehicle, and security fail, which is no insurance. Appearances again, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Yes, Your Honor, Brandon Bird on behalf of Michael Harris. Mr. Harris, can you please unmute yourself and state your full name for the record?
Michael Eric Harris.
Today is the day set for a pretrial conference. How are we proceeding?
We'd like to set this matter for a final pretrial, Your Honor.
Court is going to continue a not guilty plea on behalf of Mr. Harris and set the matter for a final pretrial conference. This is basically a traffic case though. So I wasn't ordering discovery. Is there any really discovery? I wasn't ordering discovery. This is like one of those cases that state police wasted a whole bunch of paper instead of writing tickets.
So, Your Honor, it looks like there is some paper discovery. I'll just check the IR to see if there's any body or video discovery. And if so, I'll send that over to Stevenson and or Mr. Bird.
All right, so the court is going to set the final pretrial conference. Let's go ahead and, well, is the April 16th date a good enough time for you to do that, Ms. Ritter?
Yep, Judge, I just sent paper and I just looked, there is video, so I'll send that over today.
All right, then the court is going to set final pretrial conference for April 16th at 9:00 a.m. and she just sent discovery, Mr. Bird. So if there's any video, or I think she said there is video, so she'll send that as well.
All right,
Okay.
Thank you.
Let's address. We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to and give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to. I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster,
I reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel.
Appoint counsel to me
Well,
without my permission. He has no permission to be my counsel. I am here sui juris, appropriate persona. I, Jonathan Troy Somalia Colin Schuster, am here under fraud, menace, and duress. I have made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
well, right now,
To answer them?
I am not here to be interrogated by you. You are under the jurisdiction of this. I think you understand and you choose not to take in the information. Okay, well, Mr. Schuster.
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right in my proper person. He does not have my permission to represent me in any way.
Well, it doesn't sound like you know how to represent yourself either, which you would
represent myself.
Well, you would. Either you have counsel or you are acting pro se.
Myself. And so, like I have told you, I'm here sui juris appropriate persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction or is this an admiralty maritime jurisdiction?
Either. So, right. Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, if you would like, step up so you can hear me better, and I will speak louder. I will speak louder so you can hear me, but I reserve all my rights, and I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So Schuster, I just want to make sure the reporter can hear me.
You are making legal arguments. All right, you are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will begin again so that the recorder can hear me.
You're not choosing to be silent. You're choosing to make a legal argument. So we need to have that on the record.
For the record, I reserve all rights.
You've made that.
I, Jonathan Troy Somalia Colin Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to perform under it.
Your Honor, I may be challenging 1077 in this case.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. The fact that I think it's not that you don't understand, I think it's you choose not to understand and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect
we cannot
that is
move
causing you
forward.
to not be able to
To
understand.
challenge my competency because I have challenged the jurisdiction of this court,
We're
and you have not
we're
proven
not dealing
jurisdiction.
in social security or contracts
You
or
have to prove
maritime.
jurisdiction before we can move any further.
So that's just not how it works in this court. And
No,
I don't think
that's
you
how
have
it
the
works.
legal.
You must prove jurisdiction because I've challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Jennifer, Miss Jennifer, can you prove
I'm Judge Grant, so I'm going to
Jennifer,
have you.
can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or cause.
Well, he doesn't have legal training. So that I think is
That does
clear.
not matter.
Well,
if I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody, and we cannot move further until you've proven jurisdiction.
so Ms. McDonald, what I think would be the next steps, I don't know if Mr. Parent, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance.
Okay.
So I'd ask to withdraw his.
So we could go through the colloquy, we can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I understand
We
that.
have speedy trial at
It is
August
the burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with prejudice.
Denied.
Based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you. If you'd like.
We cannot move until jurisdiction has been proven.
Yeah, this should be a.
You've failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
Right. So Mr. Schuster, did the court say that was end of August, or?
It was August 9th, is speedy trial.
Okay. So.
And if you plan on having me back here, you're taking away from my ability to provide and work. And I cannot just be coming back here because it takes my time away from working. And so if you want me back here, it seems that you have Zoom court available. I'm more than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
Does the August term start August 6th, Your Honor?
It does.
So I would request we set it during August term.
All right, so Mr. Schuster, you've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for you. You are
You
subject to
have
another
to-
court, and they could very well.
Get in trouble, and you have to prove jurisdiction. You haven't done that, and you failed to do
Obviously,
that
you
over
believe
and
that
over and
courts
over
do
again.
have
And
jurisdiction
so, I mean,
over you.
Obviously, you have to be able to prove it, and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is. And this is just a waste of time at this point. So whatever you need to do to prove jurisdiction, but I know you can. So if you want to waste more of everybody's time, go ahead. Because obviously I'm not going to allow you to threaten me anymore, which you've done.
Nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into captivity. And that's ridiculous for what's going on here. That's absolutely ridiculous. And so
I don't think
this matter
anyone
needs
is
to be
told that they're
dismissed
being
with
put into
prejudice.
captivity.
And whether we need to take this to trial or whatever y'all need to do to prove jurisdiction, I mean, go ahead. But obviously you can't prove jurisdiction. So
I'm looking for the more
waste everybody's
detailed
time, please.
counsel
Waste everybody's
waiver.
time. It's absolutely ridiculous.
I don't know that he's done that yet.
No, he hasn't. I have the streamlined version, but I want him the formal,
The detailed one.
the detailed one.
We can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power of attorney to this counsel. And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has potential jail consequences and fines. And so your rights need to be protected. This is for your benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. And I won't stand for you violating my rights. And if you're going to acquiesce, then okay, you're proving that you don't have any jurisdiction.
So this is a detailed advisement should you wish to waive your right to have counsel present and you want to act as your own attorney.
I've said over and over again that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel.
I'm here of my own right in my proper person. You know what that means.
So there's the form.
I've never signed my power of attorney away to anybody, especially this.
You need to be respectful. You are really out of line, Mr. Schuster.
I didn't say anything disrespectful.
You are being very disrespectful.
You were being very disrespectful, actually, because you're violating my rights.
So I'm going to set this on for the August term. I'm going to have you take this form.
Wasting my time.
Mr. Schuster.
When you're taking away my ability to provide and work.
Have a seat there so you can fill out this form.
What's that?
You can have a seat there so you can fill out the form.
You're dismissed. Do you need anything else?
Yes, I do. I need you to take that form. So we're going to have to go through that because this case is going to be going to trial. It's going to be set on the August term. That would be August 6th, and that will be at 9 a.m.
All right, you're dismissed.
No, you're not free to leave yet, Mr. Schuster.
I'm not free to leave?
Not yet. No, you're not.
Why am I not free to leave?
Because we are still addressing your matter.
This matter needs to be dismissed.
Yeah, it's not going to be dismissed right now. So right now it's getting set for trial.
You can't move any further until you prove jurisdiction.
And the readiness hearing will be July 31st. And that will be at 2 p.m. And that hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction,
Yes.
and you practice law on the bench.
So, Mr. Schuster, if you
Over and
choose
over
not
and
to
over.
come to your court hearings, a warrant will
Over
issue
and
for
over.
your
And you're
arrest.
threatening me again, telling me
Yes,
if I don't
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep, these are jailable offenses, but for this
Absolutely
hearing,
ridiculous, Ms.
we need
Jennifer.
your presence to appear.
Absolutely ridiculous.
All right, let's get a court date form for him.
Absolutely ridiculous.
What's the date for the intervening pre-trial?
There's issues back there.
We can set a pre-trial. Let's do it on the 22nd.
Prosecuting attorney also needs to provide any contracts that I've entered into internationally,
Here's your court date. Could you please sign for that?
especially if this is a admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So
Mr. Schuster, you are in a criminal court and there are court rules. If you wish to have,
this is a criminal matter, you said?
Mr. Schuster, if you wish to have discovery, then you need to abide by
You
the
said
rules.
it's a criminal matter?
Yes, and if you
Yes,
wish to have,
it's a-
Oh, okay. I wasn't sure you said that. Thank you.
it's a criminal matter. If you wish to receive discovery, then you will need to make.
What is the jurisdiction? Are we under an admiralty maritime jurisdiction?
No, we are not. Mr.
Are we under
Schuster.
a common law? What jurisdiction are we under?
We are under the criminal jurisdiction of the state of Washington. So if you wish to have discovery, then you need to request.
I gave you my permission to be under that jurisdiction, which I haven't.
You will need to request discovery from the prosecutor's office.
I'm not a U.S. citizen, American national. That's not a jurisdiction.
If you wish to have discovery, you need to request it in writing from the prosecutor's office, and we will send.
Your nationality was a U.S.
And then we,
and
then we will send you the discovery, all of the evidence that we have against you at trial. Did you understand that?
I don't understand what's going on with this.
So
ridiculous.
Here's my suggestion, Mr. Schuster.
Kangaroo court. And so since you guys are going to waste everybody's time even more, goodbye.
Mr. Schuster, you need to sign for your court dates. I'm giving them to you orally.
Have a good day. Talofa.
If you don't appear for your court hearings that were given today, a warrant will issue.
I'm not threatening you. Say one more word and that's 30 days. 30 days.